I am Regina Brandow from Brandow Law. I am going to be talking today about topics such as special needs planning and guardianship. Brandow Law is a law firm. We've been practicing probably over 20 years, and we've been concentrating on trust and estates, specifically special needs planning, guardianship, and elder law. We have offices from Garden City, Melville, and in Port Jefferson. Brandow Law likes to work with clients. We like to accomplish their goals. They come in with various questions, problems, and what we like to do is strategize with the clients. We meet with them, we talk with them, we understand their needs, their desires, and what they want to plan for. Planning in general is very difficult, but we will provide various options for families and or individuals so that they may feel comfortable with their plan. That's the most important thing in your life in regard to planning for your children. Special needs planning has a more heightened anxiety or more heightened concern for parents, if I could say it that way. And it's important to have a plan in place. And parents of special needs children are wonderful. They want to put a plan in place. So today we are going to talk about planning just in general for families, and we are also going to talk about guardianship when and if that is necessary. What is special needs planning? Special needs planning is a practice and a process to ensure that the supports and services are there and they continue for the life of the individual who is on governmental benefits and with a disability. So why plan for the future? Obviously, I may not be around, you may not be around, and when we're not around, we need to plan for our children. And what do we need to do? Usually there are various documents that you need to put in place beforehand. Otherwise, if you don't put these documents in place, someone else will put together a hodgepodge of a plan that may not be reflective of your wishes and your desires. So these documents usually include, of course, a will which is essentially what happens to my assets when I pass, a special needs trust, a trust to put in place now for that individual on governmental benefits, because if I leave any monies to that individual, to my loved one, and they're on governmental benefits, that may unravel those benefits that you yourself had worked so hard to ensure that would continue in place. The other documents that are just as critical is the power of attorney, health care proxy, and a living will. Those are normally called advance directives. And advance directives are so important because what will happen if I lose capacity and I need someone to pay my bills, to perhaps apply for governmental benefits for myself, and to ensure that I'm cared for. I want my family members to be able to step in my shoes, to put in place some sort of care plan for me while I'm alive, and to perhaps even transfer assets out of my name to ensure I am able to pay for that wonderful facility that I need to be in if, for example, I had suffered a severe traumatic brain injury and I could not be cared for at home. So those are the usual documents that a family or an individual needs to ensure the proper estate planning is put in place. Knowing about the typical documents that we recommend, now we have to go in further detail and tell you about the different types of special needs trusts there are. There are generally two different types of special needs trusts. One is a first-party special needs trust, and the other is a third-party special needs trust. And what is the difference? A first-party special needs trust is the trust where if you didn't do any planning and Aunt Sally left everything to the person on governmental benefits. So a first-party special needs trust would have to be established. And what type of trust that is, in the long and the short of it, is it will provide for your son or daughter, but unfortunately upon your son or daughter's passing, it will be a payback trust to the Department of Social Services. So I really try hard not to get the message out to families. I really try hard to get the message out to families that you really need to be planful so you can establish the other type of trust. It's called a third-party trust. A third-party trust is an estate plan. That means third-party money. Parents' money goes into a trust, and you don't need much to seed the trust, to fund the trust during lifetime. What we do is kind of direct the estate to the trust. So upon a triggering event, when both parents pass, it would go into the special needs trust. In that special needs trust, you dictate, you as the client will determine, obviously it's there for your son or daughter during the lifetime, and then upon their passing, who it should go to. Should it go to other siblings? Should it go to other family members? Should it go to a charity? You're in charge. Obviously, with a first-party special needs trust, which is also known as the payback trust, you're not in charge, and it will go to the Department of Social Services. And because Department of Social Services is technically the residuary beneficiary, you would have to do accountings to Department of Social Services each and every year for those types of trusts. I think you have enough paperwork in your life that you have to manage. So an annual accounting to the Department of Social Services is not an ideal situation. So I really do try hard to get that message out to clients. Everyone and anyone can leave an estate. And if you have a loved one who is on governmental benefits, it is critical for you to establish a third-party special needs trust. The other types of trusts you may have heard about are pool trusts. Now, pool trusts are generally available for those circumstances when there is an income overage. Those of you who may or may not know, Medicaid, obviously there are two types of criteria for Medicaid. First is the disability criteria. I have a disability. And then the second criteria is a financial one. And the financial one is a means test. And the means test for Medicaid is I can only have $15,000 in my name, and I can only have income of, and this is, I'm sorry, for 2020, it's approximately $15,750. And for 2020, the income, I can only have $875 monthly in my for income. Now, this is different from Social Security income. Those of you who have already applied for Social Security income, congratulations. You have Medicaid through Social Security income. You are regulated to no more than $2,000. So I wanted to differentiate that for you because some people are on different programs and everybody kind of tries to pull them all in one program, but Medicaid has various programs. Social Security has various programs. So it's important to know your benefits. I'm just highlighting these benefits for you because what will happen is when there's an overage or too much money, there are also other trusts available for you, such as a pool trust for that income overage. A pool trust company is a company that will receive the overage amount, and they will submit a annual verification of deposit to Medicaid to ensure that the individual maintains those benefits. Pool trust companies are wonderful. They've been doing income overage and dealing with verification of deposit with Medicaid for many years. They're experienced companies. If you want to give us a call, we can tell you about our experience with various pool trust companies, but they are there to help you. We can assist in establishing a pool trust for you, because there is a process that you should need an attorney to help you through establishing the pool trust and making sure you have that income overage, the right amount going into the pool trust. Other accounts you may hear about are the ABLE account. So ABLE account came out a couple of years ago, and a lot of people were very excited about ABLE account. ABLE accounts are not ideal for an estate planning purposes. ABLE accounts are very much regulated based upon the amount of money each year. Right now, they only allow up to $15,000 that can be deposited into an ABLE account for the person who's on benefits. And the person who's on benefits had to be diagnosed with a disability before the age of 26. And cumulatively, the ABLE account is only as good for up into $100,000. That sounds pretty good, but the problem is an ABLE account is also a payback to the Department of Social Services. So it is not a bank account where you can put money aside for your child as an estate planning purposes. I use ABLE accounts in those circumstances where somebody has $10,000 too much, and what to do with it so you can maintain your benefits. The other type of strategies that people do is a straight out spend down, and in order to keep Medicaid. I would not recommend that because Medicaid is under the law to advise you of these type of accounts that should be available rather than just spending down. So why plan for the future? Obviously, you want to preserve the public benefits. You want to allow private funding to ensure a quality of life. And what's nice about some of these documents, you want to provide some sort of guideline for the quality of life that you want for your loved one and the type or typical living arrangements that you want for your son, daughter, whoever it may be, your brother or sister. Brandow Law likes to work with a collaborative team effort. Obviously, our office, we work as a team. What's nice about our office is we also work with families and their own support structure, meaning any brokers, any care coordinators we've worked with as a team together. I need to validate benefits. I need to ensure benefits are in place. And then from there, we plan around the individual so we can ensure that a proper plan is in place. So what do some people do? The common mistake some people do in estate planning, what they may think they want to do is leave everything to another relative. So I'm going to leave everything to my niece, and she's going to take care of my child. The problem is with that plan is your niece is a human being. your niece is subject to creditors, bankruptcy, divorce. I could leave here today and I could get into a car accident and I could seriously injure someone and they will go after my assets. Obviously, if somebody gave me assets that I was supposed to be dedicated to my child, my niece or nephew, those assets may be taken away by those creditors. That's not a proper plan, unfortunately, and then people get worried about when the niece gets married and those circumstances and they become divorced, and those assets may be considered marital assets and not the individual niece's assets. So it's very difficult, and I think it's a poor planning in regard to that. Other issues people will do is they'll just disinherit their child, and I'm going to leave everything to someone else and I'm not going to leave anything to my child. Well, unfortunately, there are no guarantees in life, so we aren't certain about governmental benefits, and we aren't certain about your child's needs as they come up. So the whole idea is you want to ensure a quality of life for your child. You want to make sure that they're safe, they're in a clean environment, access to the community as much as possible, and to enhance their life. So obviously, I do not recommend disinheriting your child who's on governmental benefits. Okay. Why I like third-party special needs trust is when we establish a special needs trust for a family, we will give them a sample letter to give to their friends and family members. If you're thinking of leaving anything to my child, we've established a third-party special needs trust. So that way, Aunt Kathy from Ohio will leave it to the third-party trust. They won't leave it to your child. And unfortunately, I have encountered well-meaning relatives saying that they've got it covered and we're going to take care of your child. We're going to submit a bequest. And I went to an attorney and I got a trust done. Unfortunately, it wasn't the proper trust. So your advocacy that you had when your child was in school will continue during lifetime. And we generate a letter, a friendly letter. If you're thinking of leaving any money, please leave it to the third-party special needs trust. The other thing to think about it in regard to the special needs trust is your successor trustees. I like establishing a trust now during the lifetime, whereby you, the parents or the family members, open up the trust with very little money. You are the trustees, and you have a plan in place for the successor trustees. And obviously, in that trust, we carve out some exceptions for you where you can change those successor trustees. People change over a lifetime. You don't change for your love and care for your child, but maybe those successor trustees that you thought originally would be a good trustee are no longer. So we always carve out in the trust some specific instructions and allowing some powers granted to the trustees so that you can change that. What's also good about the third-party special needs trust is the governmental benefits are insured so long as you, as a trustee, properly administer the trust. When we generate a trust, we submit a letter of instructions to the trustees saying this is what it's for, how it should be done. Your child's money should never go into that trust. It's only your money or third-party money. I probably stand on my head when speaking with clients, but it is important. We don't want anything to jeopardize those benefits for your child, and obviously we don't want to cause any stress. So at Brandow Law, we always tell clients, before you're thinking of doing anything that involving the trust and you have a question about, please don't hesitate to call us. We rather you call us before the act rather than afterwards, because afterwards we usually have to clean up something. A lot of times we touch base with clients, they call up, they ask a simple question, and we always are thankful that they called to ask that question, and we answer their question saying, yes, you can do that. No, we recommend how to do it that way. So please, when you sit down with an attorney, you should have that dialogue, and don't be afraid to have that dialogue to continue. We're never too busy to answer your questions. Now, another aspect for you to think about is retirement assets. Retirement assets are usually a key component in your estate planning. Obviously, we want you to use your retirement assets for the length of your life. We want you to spend down that money. But unfortunately, we may not get there, or we'll have some monies left over, and how to plan for that. In January of 2020, the IRS came out with some new rules for retirement asset planning. And that involves individuals with disabilities and those who are chronically ill. So it's really important for you to have that specialized, secure special needs trust, a third-party trust, so that way those retirement assets are benefiting your loved one for their lifetime. Otherwise, if you don't properly plan, what may happen is that the funds would have to be distributed in a short amount of time, and it would be generated at the income rate, and the income tax rate for the individual or for the trust could be at a very high rate. So your hard-earned retirement benefits that you've saved for are going to be chewed up by the income tax rate. So it's really important for you, when you sit down and speak with an attorney, is to plan for those retirement assets. So how do you fund the trust? Funding the trust could be various ways. Obviously, in a bequest, in your life insurance. So when I pass, I will name the third-party special needs trust. In my will, I'm going to name the third-party special needs trust. So my stock accounts may benefit the special needs trust, or part of my will, my executor, what they'll do is gather all my assets. It's called marshaling all the assets. It could be all my bank accounts. It could be my house. And a lot of people are concerned about the homes. Well, what about the home? Will my child get to stay in the house? Unfortunately, that takes a very complex decision making, and what we try to do is plan to be as flexible as possible to give the executors and the trustees as many options, so your child, if they wanted to stay in the home, can stay in the home, or they can stay in the supported housing that they're living in, or they could purchase a condo or a co-op, and so on. So we try to give families as many options for real estate, those living arrangements, for when you're not there. Now, permissible special needs trust distributions. People always ask, what can I spend it on? How can I spend it on? I think it's always over and above what the governmental benefits provides. So the governmental benefits are going to provide that ComHab worker. They're going to provide maybe some housing. They're going to provide monies for food and shelter. So the special needs trust, also known as supplemental needs trust, are to supplement those benefits. So again, it's about quality of life type of purchases. So the typical ones could be, I need a new laptop for my hobby. I need to purchase a new van. Now you have to be careful about those types of things. So sometimes with a van or a vehicle, there's the auto insurance you have to consider, and also what benefits, if anything, will be covered for that specialized equipment. Another important aspect is perhaps dental work. Some dental work is covered by Medicaid, but other dental work isn't, and dental work is expensive. The medical, medical usually is covered by Medicaid, and then a lot of times your loved one may have a secondary insurance provided by your own family plan, or if they're on Medicare, because some individuals on governmental benefits are on Medicare. So you have to determine always first what benefits are going to be applied for, and then the trust is there to pay for anything above that. Obviously, haircut, salon services, fitness equipment, clothing, cameras, vacations, those are slam dunks. A few quick pointers for families. Those who are applying for Social Security income, please, I would recommend that you sit down with a person who is knowledgeable and experienced in helping you apply for Social Security income. You want that application to go through on the first time. Likewise with OPWDD. You want that application to go through on the first time. So it's really important for you to sit down and speak to individuals very experienced. So in your school district for OPWDD services, you can speak with the transition coordinator and ask them about their experience with submitting the OPWDD submittal form and all the necessary evaluations. You want it done correctly and the first time. So if your transition coordinator doesn't do that, what I really would recommend is you seek out agencies that could assist you with that. Likewise, with the Social Security income, we know various agencies that will assist you in applying for Social Security income, and believe me, it is imperative, because if you get denied, it just takes too long to reverse and get that appeal done. Now, once you're on Social Security, backing up, the asset threshold for Social Security income is $2,000. So before you even think about applying for Social Security income, you are going to review all of your child's accounts, and you're going to review their 529 accounts, those college accounts that maybe you funded a long time ago or grandma did, and your child is a beneficiary of, and also those savings bonds, those persnickety savings bonds. And they will come up. Maybe they won't come up on the application, but a year later they will come up on the Social Security will have a trigger, and they will see that those savings bonds have been in your child's name for a length of time. So what will happen is you may have a payback situation, and that's not what we want. So please be diligent, look through all those accounts, look through the savings bonds, and make sure you get those assets out of your child's name, and maintain, once you're on SSI, maintain less than $2,000. And some parents like to have one account for their child and the payee representative. I couldn't do that. You just need one account. It's the payee representative account. because if you have two accounts, you have to keep track of both of those accounts, because if once they go over 2,000, the alarms and bells are going to go off. It may not happen that first month, second month, or the fifth month, but maybe by the eighth month, and they will go back in time to see those funds that have been available since then, and again, a payback. So that's my tidbit for you today. If you, as parents, you're so good and you really work hard, but make sure you work hard in looking through those accounts. So the next topic we're going to talk about is a guardianship. Why would you even need a guardianship? Unfortunately, for individuals that have a developmental disability, there may be a requirement that you need a guardianship because they functionally cannot make decisions, medical decisions, for themselves. You are the parent. You've been making decisions for your son or daughter or your loved one for many years as they were growing up. When they turn 18, technically they are considered an adult. So those medical providers are going to be looking to them to make those decisions. And unfortunately, some individuals can't make those decisions, and you will have to make those decisions for them. So it's really important, if you want to continue to make those decisions as a parent, as with the medical provider, that you apply for guardianship. And guess what? We have a free guardianship workshop up on our website. Please take a look at it. The forms are available. Under the statute in New York State, parents or loved ones can do it themselves, and we really wish you would take a look at it. I think it's informative. It's not very exciting. It's about 2 hours long, but you can stop and go back whenever you want to. But again, it's for those individuals that cannot make decisions for themselves. And sometimes it's kind of hard whether or not you determine if your child can make decisions for themselves. So I'm not a psychologist. I don't have that degree after my name. So you might want to sit down and talk to your psychologist, talk to a psychiatrist, and see if your child could make those informed medical decisions. If they cannot, please take a look at our website. And after you looked at our website, Brandow Law does offer different types of packages, if I could call it that. If you do part of the petition, you want us just to review it, or if you want us to do it, from soup to nuts, we provide all various packages for individuals, and we do offer a payment plan. It is important for the guardianship, obviously, because you want to make those medical decisions. I think if I were applying for a guardianship, I would like to get some life out of it, because under the statute, under the current statute, under the 17A statute, I do not have to report in annually. This 17A statute is different from an Article 81. The Article 81 is in Supreme Court. It's more expensive. There's annual reporting requirements versus the 17A, where you are technically a guardian for life. Now, I am just talking about guardianship of the person. I will touch upon guardianship of the property. You could apply for guardianship of the property in the court while you're applying for the person, but technically your child has to have assets in their name for you to apply for guardianship of the property. That is not the payee representative account. So don't think you are the payee representative for your child that you need to file for guardianship. You already have the authority under the Social Security Act as the payee representative to take those funds out and to pay for their living arrangement. So the guardianship of the person, why it's critical, obviously, is the medical decisions. And what I generally advise families is to, if you have the parent came to me and they want to be the guardian, and naturally so, but I would recommend that if you could make if there's a sibling, another relative, a niece, nephew, cousin that is younger than you, that they could be a guardian. That way you can have longevity out of that guardianship, because I don't know if and when the statute will change and there will be annual reporting requirements. And what's really critical is that person is appointed guardian. So if something happens to you, they're already a guardian, so they can help your child when you're not there. And that's what we're talking about today, is planning when you're not there. So the guardianship always looks at 2 doctors' affirmations in summary, and the doctors will submit affirmations that essentially state, due to the person's disability, that they are unable to appreciate and comprehend certain decisions and risks and benefits. So that's why, and it's always critical when you're applying for a guardianship to think of 2 MDs or 1 MD and 1 psychologist that could help you. Now, a lot of people, when you're looking at that video workshop, I want you to be aware that you don't need to get evaluations done for the guardianship. You may already have them. It may already be in your school district packet. You get an IEP and you get evaluations every 3 years. A lot of times those evaluations will tell us critically the information necessary whether or not your child will qualify for a guardianship. So the court the court clerks for both counties, Nassau and Suffolk, are very friendly. They're there for you, but I will just advise you that the court is under a budget. So the staff is short and the petitions are many. So please be patient with them. And what's nice about them, if you do it yourself, is that they will explain what is needed. They will explain in writing to you. After the process is done, the guardianship decree will come to you and guardianship letters will be issued to you, and you will be named a guardian. And you can see that you're named, and there's no annual certification. It's not like a guardian for the year. It's guardian for life. And backing up, I did not mention about standby guardians. I would have a list of people that I would consider important. And a standby guardian is not acting now. They're just waiting in the wings. So if something happened to you, that standby guardian would have to notify the court. They would have to be fingerprinted. That's very important. You want them to be fingerprinted because the court will review their background, make sure that this is a good person for your child. So you can name the standby now, and let's say many years later, when you pass, the standby says, "I'm ready," they will be fingerprinted. And during that time, if a felony comes up, obviously that's going to thwart them being a guardian. So I always advise people to try to think of as many good people in your child's life as possible. And it's not easy, and they have to be over 18. Some people say, "Oh, my son's cousin would be perfect. She's only 16. You can't name that person on the guardianship petition, only when and if they're over the age of 18. Now, during the process, when you submit that petition, the court is going to review the affirmations. They're going to review your petition. They may have questions about your child's disability. They may have a hearing. That's okay. Don't be frightened. They just have some questions, and they want to establish on the record that it's needed for your child. The other thing is CPS searches may come up, or some background, criminal background for parents or individuals. As parents, I don't want you to be frightened if you had a criminal background search in your background. Unfortunately, between the ages of 16 and 26, all of us were developing a frontal lobe and may have made mistakes. So what we try to do working with families is we submit an affidavit, we explain it, so that way the court knows of it and the court will know of it. Believe me, I've asked parents these questions and they say no criminal background, and then the court will come back with something from 1983 and oh yeah, I forgot about that. I thought that was expunged. They will know of every incident and also if there's any CPS filings. Unfortunately, if you're divorced, there may be some CPS filings that are unfounded. The court is aware of those things, and perhaps during a hearing they will need to be explained to be put on the record. Because what is the court's concern? They want to make sure that guardian is a good guardian for your child. And some people get defensive. Don't be defensive. Share the information. Know that it's going for the right reason for the safety of your child. Well, it was a pleasure speaking one way with you. Unfortunately, with this 2020, we can't meet in person. But I want you to know our office is available. At the end, we will have contact information. So if you have any questions about the wills, trusts, advance directives, and or guardianship, we do offer a 10-minute consultation, free of charge. We'll answer your questions just like we were there in person. You could go to our website also. We have a wealth of information. And please don't forget about the video workshop that's available for you to look through. And that could answer a lot of your guardianship questions. So please look through that. And I want to wish everyone good health and safety for you and your family. And we're here. We offer consultations via Zoom, telephone. We do offer in-office. We have our masks. We will put them on for you. And we have the ventilation for you. So be well, and thank you again.